Generally, all matters that are civil or commercial in nature are fit for mediation. But there are some matters or disputes that are not capable of being resolved by mediation owing to legal and public policy reasons. Taking a leaf out of arbitration, let's call the test mediate-ability, modifying the term arbitrability, the capacity of a matter to be mediated. The Arbitration Act does not set out non-arbitrable disputes, neither as broad categories or as a specific list. Very recently, the Supreme Court in Vidya has classified non-arbitrable matters into certain broad categories. Thus, matters relating to actions in rem, sovereign and public interest functions of the state, matters affecting third-party rights and those requiring central adjudication, and matters that are made non-arbitrable by a statute are held not arbitrable, not fit for arbitration. The Mediation Act goes a step further and provides an indicative list of non-mediatable disputes. In fact, all the broad categories mentioned by the Supreme Court in the context of arbitration are more or less listed. As such, the declarations having the effect of right in rem, disputes which have an effect on the rights of a third party, except matrimonial disputes where the interest of a child is involved, disputes by law are required not to be submitted to mediation, and disputes involving prosecution of criminal offenses cannot be mediated. The Mediation Act also lists out a few other matters, not exactly creating new categories, but rather identifying specific items. Thus, disputes relating to claims against certain persons, minors, deities, persons with intellectual and other disabilities, disputes relating to tax matters and land acquisition matters, disciplinary proceedings against professionals, doctors and lawyers included, before any concerned statutory authority are all excluded as not fit for mediation. There is an interesting proviso to this particular section that deals with mediatability. As such, the courts may refer any dispute relating to a compoundable offense, which is not generally fit for mediation, to mediating procedures. These compoundable offenses include matrimonial offenses, except that the outcome of such mediation of a dispute relating to a compoundable offense, will be further considered by the court in accordance with the law before they can become final and binding on the parties.